the next major issue, which is a really interesting development in our Clinton email case. Now, you may recall, if you're a regular viewer of the weekly updates here or follow our work, you know that a federal court has authorized discovery into the Clinton email system, its operation, and what the State Department and DOJ knew about it, who knew what and when, and the court was not happy with what we found and authorized Hillary Clinton to be deposed by us in person. And the judge issued that ruling, and Mrs. Clinton, in a desperate move, appealed it. And so now that's on appeal. And we are, all the papers have been filed. And so we expect to hear from the appellate court relatively soon as to what they're going to do in terms of either setting a hearing or otherwise handling the papers. Now, the court authorized two other discovery opportunities for us. One were one former, I think one's former, but one's current State Department employees who were, one was in the Clinton office who was in an IT position, and the other was another IT official who was handling the emails after she left. But on top of that, there's this issue about Google, because Paul Gambetta, who was an IT specialist for Hillary Clinton and he was a private person, worked for Platte River Networks, the company you may have heard of, he supposedly sent all the emails to a Google address. And the judge was very interested in that, and he authorized us to subpoena Google, because one of the things he wants to do is figure out whether or not there are ways to get the emails that we have a right to under law. Remember, this lawsuit is about the Benghazi attack, one of the worst scandals in American history. And we have a right to the emails about it. I mean, that's the FOIA. That's the Freedom of Information Act. And she took all of those emails. She destroyed half of them. And the court's like, well, where else might they be? So he authorized us to take some discovery there. And I want you to read, or I'm going to read for you the let me see here. Oh, wait. Oh, Judicial Watch subpoenas Google in Hillary Clinton case. So Judicial Watch announced that we served the subpoena. We served it on Google in this week, I think it was delivered. And he first raised the issue, and the judge raised it on his own, I think, in August of 2019, where we had a big hearing about it. And he ordered Judicial Watch to shake the tree on the issue. He said, and this, I'm quoting from the transcript, and it was Judge Lamberth was referencing Senator Grassley, who was raising issues about this. He was raising this in a report that he had publicly released. And this is a quote from the transcript. A report in which he, being Senator Grassley, had some very troubling information about a guy named Gambetta, who had been one of the contract employees on the Clinton emails. And he and the senator who chairs the Homeland Security Committee, Grassley and Ron Johnson, released in the Senate this report. And the gist of it was that Gambetta had said, I guess, that he had created a dummy email account with all the Hillary Clinton emails in it in a different name. And the FBI to investigate that to see whether or not the Chinese had ever hacked into it. There you go. They had determined that the Chinese hadn't, but that the FBI never told the State Department about that account, and that the emails that were not given over to the state could have been obtained from that account, but the FBI never told the State about it, the State Department about it. So it leaves out in the open whether there are these other emails that state could have obtained, but nobody ever bothered to tell state about them. I don't know the status of that, and I'm sure you don't either, but that did occur to me that would be a problem for me as to whether an adequate examination of that circumstance occurred, and assuming that Gambetta deleted them, as he said that he did before he took the fifth, I guess, whether or not the server that they were on, or wherever they maintained the server, or whoever maintained the server, whether they can be reconstructed. And he then detailed the report released documents revealing that Clinton IT aide Paul Gambetta copied all but 4 of the missing emails to a Gmail account that does not appear to have been reconstructed in search. The court thinks Judicial Watch ought to shake this tree. So he ordered that we are allowed to seek a subpoena. And of course, you know what? State Department and Justice Department opposed our efforts to do this. They fought us. And the court has said, no, we can get the subpoena. The Justice Department and State Department are wrong. Again, this State Department, this Justice Department. The court is not confident that the state currently possesses every Clinton email recovered by the FBI, even years after the FBI investigation. The slow trickle of new emails, because the FBI is, quote, still finding magically new emails, has yet to be explained. For that reason, the court believes the subpoena would be worthwhile and may even uncover additional previously undisclosed emails. Accordingly, the court grants this request, and it was our request to issue a subpoena. So as I said in our release, the court's tired of the gamesmanship by the State Department and the Justice Department, and that's why he authorized the release or the subpoena. You know, and State and DOJ have been AWOL on this, and AWOL is actually a nice way of putting it. In fact, they've been opposing us. I highlighted the fact that the State Department, Justice Department couldn't go as far as to agree with Hillary Clinton's emergency appeal of her deposition ruling. But as I highlighted, they had actually tried to oppose her deposition in alliance with her and allegiance with her against Judicial Watch. So they're still fighting us.